I'm George Whipple, one-on-one with Courtney McFate. Welcome, how are you?
I'm great. How are you doing?
I'm doing great. Look, you describe yourself as a rule follower. You're a rule follower.
Yes.
Talk to me a little bit about that.
I started my career as a litigator in California and, didn't have much business experience. And really there was a black and white answer for everything. When I went in-house, I quickly realized that saying no to everything that the business proposed was not going to win me any friends and was not actually what was right for the business. I see my role now as a result of that experience and others as an advisor, someone that can say, I see your plan or I see your proposal for this particular sale, let's say. It's an amazing proposal. However, there are risks. And here are the risks. There are usually ways to be compliant and, follow the law closely and carefully, but also get your business objectives completed. And so I see that as my role very much.
I always tell my clients when they take over the job of head of employment law, this is a great opportunity for you to go in, look at your workforce, make sure your wage and hour stuff is in compliance. We should do our own audit, if you will, or review, or whatever you want to call it. A lot of times they say, well, we don't want to spend the money doing that, George. We're just willing to take the risk. How do you prepare to either defeat a wage and hour audit by the Department of Labor, but also defeat a claim for someone either bringing a PAGA action or a direct wage and hour action?
Yeah, so it's a bit different for each, but the concept is the same. And as you mentioned, the internal audits typically performed with the help of counsel so that they remain privileged. Those are your best defense against the Department of Labor audit and wage and hour litigation, whether a single plaintiff, class, or PAGA action. The cost is prohibitive for some of our clients, but when we explain the potential multi-million-dollar penalties and damages, and not to mention attorney's fees, which of course drive the bus on a lot of these claims too, when we mention those to them, they seem to understand that this is actually a very good idea. It'll save me money in the long run. I think some of the things that I help my clients do when proposing an audit is talking to the business about the audit, talking to the general counsel about the audit and why it makes sense. Because those are the people that our clients are going to have to get the authority from really to do these audits. And so helping them make a business case for why this audit is important and why it should be done is one of the things that I help my clients with.
What should employers know about a DOL wage and hour audit?
Oh, there's so much, George. The first thing they should know is that the pace is very fast. So in many audits that I've helped clients with, they get a letter from the Department of Labor the day before saying you're being audited and we are going to actually come to your work site the next day. Not only that, we're going to look at every single posting that you have. We're also going to interview your employees and no, you can't be present. I'd also want them to know that even the most compliant clients, the ones that, take wage and hour compliance extremely seriously, there will be an error discovered in your records. So I do counsel them and let them know we recommend doing an internal audit while the DOL is doing their own audit. And any issues that EBG finds while we're doing an internal privileged audit, we will help them correct those before the end of the audit so that at the final conference with the Department of Labor investigator, we can say, yes, we're aware of that issue and we've made these changes. It's no longer an issue.
Let's say a client gets a letter from the DOL or a wage and hour class action complaint is filed. What do they do first?
The first thing is evidence preservation. So it's something that...
The first thing is pick up the phone and call you.
Oh,
That's
of
the
course.
First thing.
Okay, let me
After
start
they
that
call
over.
you, what do you recommend they do next?
Yes, so definitely they should call their counsel immediately. The second step then is we help our clients with evidence preservation. So it's a legal obligation that you have to preserve all related evidence. So that's step one. Step two is preparing your strategy for how you're going to respond. For a DOL audit, my practice is typically to pick up the phone and call the Department of Labor investigator and to say, hey, my client needs extra time. to push back on the document requests that are from the DOL because they're very onerous. That's typically my practice.
Well, Courtney, thank you so much for spending time with us. I'm going to be picking up the phone to you. That's going to be the first thing I'm going to do. And it was a really great pleasure to meet you and spend time with you here.
Same.
Thank you very much.